Good morning, good afternoon, good evening to everyone from whatever part of the globe you're joining us from today. On behalf of the Chartered Institute of Arbitrators Nigeria branch, I welcome you to what promises to be not only a most insightful but interesting 1 hour and a half. My name is Diane Okoko, and I will serve as your moderator for this webinar. The concept of Islamic arbitration is one that is new to most ADR practitioners and one mostly shrouded with the mystery normally associated with not knowing. However, the idea of Islamic arbitration or Islamic contracting is not really new. It has existed for as long as Islam itself has existed, and as a religion too. The peculiarities of Islamic contracting, which itself must exclude contracts which are haram or contracts which are fasid, or which even have an element of these things contained in them, have in recent times now, found their way into financial transactions. So most people are thinking of contracting financial transactions that are devoid of the components of haram, and for contracts which make provision for riba or for gara. Gara is uncertainty or the element of risk in Islamic contracting. Now with the increasing demand for ethical financial transactions, come a corresponding demand for arbitrations to settle these disputes emanating from such transactions in a way that aligns with the principles of Islamic financial contracting. The question is dispute resolution mechanism different just because the transaction is more faith-based? Or are there elements of contracting that are different under Islamic financial transactions from non-Islamic transactions, that are tilted towards the more secular or commercial, kind disputes? But I'm not the one to answer these questions. These and many more of your questions I know are coming, and we will attempt to unpack all of these questions in the course of this webinar. To help me do this is a panel of some of the best minds in the field of Islamic finance, in the field of Islamic dispute resolution. And in no particular order, I have on the panel today with me Dr. Ahmad Hussein. Dr. Hussein is an international arbitrator, he's a mediator, he's a legal counsel and academic with a distinguished career spanning both secular and faith-based dispute resolution systems. He's currently a senior research fellow at the Singapore International Dispute Resolution Academy and serves on the International Supervisory Board of the Organization of Islamic Cooperation Arbitration Center, I beg your pardon. He's empaneled with several leading arbitral institutions worldwide, including the ICC, the Singapore International Arbitration Center, SIAC, the International Islamic Center for Reconciliation and Arbitration, and the Saudi Center for Commercial Arbitration. Dr. Hussein brings to this discussion a deep expertise in Islamic finance and dispute resolution. Today, we are honored to have him join us. Joining us next is Dr. Umar Hosseini, who is the Secretary General of the Organization of Islamic Cooperation Arbitration Center, OICAC, who we have the privilege today of partnering with for this webinar. Prior to this, he was the CEO of the International Islamic Liquidity Management Corporation. Dr. Umar is a member of the Governance and Ethics Board of the Accounting and Auditing Organization of Islamic Financial Institutions. He is also a member of the Financial Regulation Advisory Council of Experts of the CBN in Nigeria. The CBN is the Central Bank of Nigeria. Recently, he was appointed a member of the advisory board of the Islamic Philanthropy Fund of the United Nations International Organization for Migration. He doubles as a visiting fellow at the Islamic Legal Studies program of Harvard Law School, as well as being a Harvard certified mediator and negotiator, as well as a dispute resolution expert on, Harvard certified. We're grateful to have Dr. Hosseini joining us today. Last but certainly not the least is Ibrahim Hussein. Ibrahim Hussein is an internationally recognized conflict resolution expert. He is the founder of Sulha Solutions, a global Muslim dispute resolution organization, and serves as a member and arbitrator with the Toronto Commercial Arbitration Society. He's also a roster mediator for the Ontario Mandatory Mediation Program at the Ministry of the Attorney General. With it, much pleasure, I welcome the trio car of the Husseins. So we've got Dr. Ahmad Hussein, we've got Dr. Umar Husseini, and we have Ibrahim Hussein. So thank you for joining us today. And let me begin with you, Ibrahim. Now, from an Islamic ethical perspective, right, how do we define fairness in financial transactions? Not just in terms of legality now, but in terms of conscience, justice, and accountability before God and even before man. What are the basic elements of contracting that Islamic financial contracts must have? How are these different, if at all, from everyday commercial contracts? Over to you, Ibrahim.
Greetings and blessings to all of my esteemed fellow panelists and also to you, our honorable and lovely moderator, Diane, and to all the honorable organizers and attendees of this exciting webinar. In Islam, financial transactions are not just about legality. They are about achieving justice, fairness, and ethical accountability. This idea is clearly articulated in the Holy Quran. In particularly, it is stipulated in Surah An-Nisa, which is chapter 4, verse number 58, which commands, wherein God Almighty, He states that indeed Allah commands you to render trusts to whom they are due, and when you judge between people, to judge with justice. Notice two key concepts here. First, that every transaction is a trust, which is also known as an amana. And second, that judgment, whether in dispute resolution or enforcement, must aim at justice. For arbitration professionals, this is especially significant. In our work, disputes often arise not from technical illegality, but from breaches of trust, unfair advantage, or perceived inequity. Islamic principles guide us to address these issues at their roots. Let's look at Islamic financial contracts. They are structured to ensure fairness and trust. Number one, they have to have a clear offer. A clear offer must be included an acceptance, ijab and qabul. Parties must voluntarily agree to all the terms. Number two, the subject matter must be lawful. The contract must avoid prohibited or unethical activities. Number three, there has to be clarity and transparency. Obligations, pricing, and responsibilities must be explicit, reducing the risk of disputes. A fourth point I want to make is that the contracts should contain within them mutual consent without coercion. No party can be forced or misled into an agreement. Additional rules such as prohibiting excessive uncertainty, gharar, as you mentioned earlier, or interest, riba, strengthen fairness and equitable outcomes. In arbitration, these principles provide a framework for examining disputes beyond the written contract, allowing us to consider whether the transaction upheld fairness, trust, and moral responsibility. Consider this practical example, a profit-sharing contract where one party feels they did not receive a fair share. The contract may be legally valid, but an arbitrator guided by these principles will look beyond technical compliance by assessing, number one, was the profit sharing mechanism transparent and agreed upon freely? Number two, was any party misled or disadvantaged by ambiguity? Number three, can remedies restore fairness and trust rather than simply enforcing rigid terms? Compare this to conventional commercial law. Standard contracts often ask, does this meet formal legal requirements? Islamic contracts, inspired by chapter 4, verse 58, ask, does this achieve justice and fulfill the trust? This aligns closely with arbitration goals, where our mandate is not only to enforce contracts, but to restore balance, equity, and confidence between parties. In conclusion, Islamic theology frames financial dealings as trusts requiring just treatment, emphasizing that fairness is both a legal and ethical obligation. For arbitration and ADR professionals, this perspective offers a holistic lens. It reinforces the importance of clarity, consent, and equity, while reminding us that the ultimate goal is restoring justice and maintaining trust, not just enforcing technicalities. By integrating these principles into arbitration practice, we can resolve disputes in a way that is just, ethical, and sustainable, ensuring that parties leave the process feeling heard, respected, and fairly treated. These are my thoughts. I appreciate your attention.
Thank you very much, Ibrahim. You surely have set the pace for us. And beyond knowing that the tenets of Islamic contracting have the elements similar to non-Islamic contracting, it is comforting to know that they actually could sit in non-Muslim kind contracting. So taking off from there, I will come to you, Dr. Umar. And, knowing what Ibrahim has said about the tenets of Islamic contracting, how does Islamic finance integrate faith, ethical principles, and financial fairness into its framework? Dr. Umar, if you can hear me, please. Dr. Ahmad,
Yes, it's fine. It's fine.
I thought, Dr. Umar has an issue. I will go back to Dr. Umar, but please, if you may, just go ahead with that question.
Thank you. First of all, I would like really, until our colleague Dr. Omar joined us, I would like first of all to thank the CIR branch in Nigeria for organizing this fabulous event. And I am really honored and pleased to be with my fellows, my colleagues, my friends, the distinguished speakers, yourself, Diane, and in spite of this month, a little bit extremely busy time, but again, it's my honor to be here. Before I start, since you have highlighted the presence of the three Husseinis in this panel, which it's my pleasure, I also would like to highlight the three F in this webinar. I think the faith is promoting the fairness. If you have a faith, for sure, that will sustain your faithfulness. And by faithfulness, you'll be able to serve the finance. So the three F's here in this webinar, they are really of high meaningful. Back to your question about the positioning of Islamic finance within the other jurisdictions, I think we have to make sure of three important points here. The first thing we need all to understand that positioning the Islamic finance within conventional finance It doesn't mean we have different schemes, but for example, if I'm coming from a common law background and there is also a civil law background and a third background which is Islamic Sharia or Islamic finance, we need to understand that this Islamic finance is not just one system. It depends on the school of jurisprudence in which such Islamic finance is rooted, whether it is Hanbali or Maliki or Shafi'i or other jurisprudence, Islamic jurisprudence. And this is one of the challenges if we just say Islamic finance for as in a pure term. And that's why the international Islamic organizations with their standards similar to the conventional institutions like the IBA, like the ICC, like LCIA, whatever, they have their own rules or their own standards that we need to be fully aware. So the first thing we need to understand that this is related to Islam, related to Islamic rules, but which rules, which principles, that is the mandate of the commercial lawyer, of the in-house lawyer, of the practitioner to understand and to put this in the context. I think there is no, I can stop here and you can give the time to our friend Dr. Omar who joined us now to just to proceed and commenting on that with your vast expertise in this field. Floor for you, Omar. Dr. Omar.
Yes, I can see that, the last Hussein is here with us now. So, Dr. Umar, just before your technical hitch got resolved, Dr. Emad had very aptly started on the convergence, of Islamic finance and the secular. So please go ahead.
Yeah, thank you very much, Dan. And I'd like to thank Dr. Imad, and it's glad, to be here. It's good to also see Mr. Ibrahim joining from Toronto. And yes, hello, everyone. It's really indeed to be here today and to be part of this webinar. Let me start with one quick hypothetical question. And this question goes to all the participants, wherever you're joining from. I will expect that you answer this question in the chat box of the Zoom platform. And the question is this: does money or financing have any religion? And I will repeat, does money or financing have any religion? So I'll expect your answers in the chat box, and let's see what comes out there. Now, I'm going to pause for a while to allow you to type your answer in that chat box. Okay. Quite interesting to read some of the comments that are coming in now. According to Thomas Jefferson, an American founding father who served as the third president of the United States from 1801 to 1809, quote, "Money does not have religion." Now, everybody needs money, as you all know. Just yesterday, we received the news that the Federal Executive Council of Nigeria has approved 125 million US dollars funding from the Islamic Development Bank. For which state? Abia State. And this is for Abia State Integrated Infrastructure Development Project. Now, for those of you who are not Nigerians here today, Abia State is predominantly non-Muslim state in Nigeria. Now, this is just the latest funding announcement, and there have been numerous previous Islamic funding interventions for projects across Nigeria. Now, on the global scale, I'm sure most of you are aware that the United Kingdom has issued 2 sovereign sukuk, which people refer to as Islamic bonds. Now, the first sukuk was issued in June 2014 for £200 million. And I think the second one also came in, I think that was in 2021. And that was actually £500 million. Now, what I want to bring out from this whole discussion is this. Apart from numerous sovereign sukuk issued by the federal government of Nigeria to develop roads across the country, we have also seen other European countries, such as Luxembourg, that have issued sukuk, that is Islamic bonds, to finance key projects. Therefore, it is clear that Islamic finance whether through its various sectors such as sukuk market, banking, insurance, or even capital markets, is a topic that might seem complex, but is at its heart quite simple. And I'm sure Dr. Imad has told you a lot about this already. Now, when you have such financing arrangements and contracts involving people, it goes without saying that there is a need for some sort of regulation. So even though money or financing does not have religion, as most of you have answered, I can see the poll. Thank you, Dan. Now, we actually have to look at the aspect of regulation. So even though money or financing does not have religion, when contractual relations are established, where people part away with their hard-earned monies, there's a need for some sort of regulation to protect the weak and unsophisticated investors. Now, to do this, this is where the question comes. The question is that what kind of regulation are we envisaging when we talk about Islamic finance? In the context of Islamic finance, the regulations are based on core Islamic ethical values of economic justice, fairness, and equity, which are often derived from the primary sources of law in Islam, generally known as the Quran, which Muslims regard as the word of God Almighty, and the Sunnah, which I simply translate as prophetic precedents of Prophet Muhammad, peace be on him. Now, the faith-based regulations are not so different from the fundamental principles of fairness in other Abrahamic faiths, including Christianity and Judaism. Then how do we then define Islamic finance in simple terms? Islamic finance is a system of finance that is guided by faith-based principles of Islam, but its core tenets, which are fairness, ethics, and social responsibility, are universal. At its most basic level, Islamic finance prohibits interest or usury, which is known as riba, which is a common term, Muslims use. The reason behind this is that money shouldn't be a commodity that generates more money just by existing. Instead, wealth should be generated through real economic activities such as trade, investment, and production. I'm sure most of you joining from Nigeria are familiar with the phrase from consumption to production. I don't want to say more. Now, with that, you can generate more employment opportunities and promote economic empowerment. Now, think of it like this. Rather than lending money and charging interest on a loan, an Islamic bank will partner with you on a venture, sharing in the risks and rewards. This brings us to the key concept of profit and loss sharing. This principle is what makes Islamic finance so different. Both the financial institution and the client are partners in a transaction. Now, for example, instead of a mortgage, an Islamic bank might purchase a house and then sell it to you in installments at a higher predetermined price, or it might enter into a profit and loss sharing agreement where you both share ownership of the house and you gradually buy the bank share. This encourages a relationship based on what? Mutual trust and shared responsibility. Now, very quickly, another fundamental principle in Islamic finance is the avoidance of speculation and risky transactions. This means that financial products must be tied to a tangible asset or real economic activity. The goal is to reduce uncertainty and excessive risk, thereby promoting stability and preventing purely what? Speculative bubbles. I'm sure you are all familiar with what led to the global financial crisis in 2008, a massive speculative bubble in the US housing market, which was fueled by subprime mortgages and complex financial products, burst and triggered a chain of what they call chain reaction that collapsed the interconnected global financial institutions, leading to what they call the GFC in 2008. And finally, I can see Diane smiling. Islamic finance avoids investments in industries considered harmful or unethical, such as alcohol, gambling, tobacco, and sex and child slavery, and even pornography. This is where faith and ethical principles directly intersect with financial practice. By adhering to these guidelines, the system actually aims to promote what you call a just and equitable society where wealth is distributed fairly and responsibly. And in essence, Islamic finance is about building a financial system that is not only profitable, but also ethical, fair, and aligned with the well-being of the community. And I always say it's a model that places faith and commitment to justice at its very center. In such a financial system, one cannot overemphasize the role of lawyers and dispute resolution experts. I'm going to come back on that point later.
You know, the thing is, as soon as you give the floor to a fellow of the Harvard Law School and a doctor, you know that you've just gone to school. So it is difficult to rein them in when they begin to speak. But thank you so much, Dr. Umar and Dr. Ahmed as well, you know, for letting us know that it's more a partnership than anything else when it comes to Islamic financial contracts. And on that note, I will come back to you, Dr. Ahmad. Now, we know that Islamic finance contracts often reference compliance with Sharia principles without clarifying which school of jurisprudence applies or how conflicts with national laws are to be resolved. This is very important because when it comes to arbitration, we do know that there is the universal, precedent, which would be mostly the model law. And most domestic laws have modeled, their own domestic laws after the model law. So, we now want to know, based on your experience, right? How can parties draft arbitration clauses that ensure both Sharia integrity and procedural clarity? It takes us back to the New York Convention, which I'm sure we will discuss later on in this webinar. But please, help us answer this.
Thank you, Jen. This is really an excellent question. Before I answer this very important question, I'm so pleased that it's almost more than 740 in this webinar, which means we have an excellent pool of lawyers, practitioners, business people. I mean, it's really great to have such knowledge cafe or knowledge corner now, which we are all sharing and carrying this information. So I'm so pleased with that attention. Honestly speaking, practically speaking, Diane, your question is an everyday question. And for the best interest of time in this webinar, I just summarized what I normally share with my colleagues, whether in the North Africa or the Gulf states, and every part of the world when this question arises. And the most important point here, we have to be reminded that we are not drafting clauses. We should be crafting. The difference, as we know, between drafting and crafting is that in crafting, you are not just thinking about how the contract will be in operation, but you think, you visualize, you anticipate how the dispute will be also managed if arised. It is not only the contract, but it's also the dispute. That's why in most of the jurisdictions, advanced jurisdictions, leading jurisdictions now, when it comes into legislation of investment laws, they integrate the dispute resolution to be an integral part of the journey of the investor to ensure that it is not just to attract or to increase the FDI, foreign direct investments, but also to be ready when the dispute arises. With the mindset of crafting rather than drafting, I would focus on three key issues, and this is only for the interest of time, otherwise we should need another 3 or 4 days. First of all, we should be aware that we have to maintain the balance between legal and procedural integrity and also the Islamic finance requirements. That is because the parts, when they stipulate Islamic finance clauses or Islamic finance principles, for sure they have good intention. They have good faith. But having good faith is not enough. You should be able to manage this good faith. So the first consideration, and for the time being, I would invite my colleagues to remember the SCC. The question is, what does S and C and C? The answer will be at the end. But the first consideration or technique for my colleagues, whether they are whether in financial institutions or commercial lawyers or dispute resolution practitioners, the first consideration is to make sure that to specify which interpretation of Sharia. It is not enough to say in your clauses based on Sharia principles or based on Sharia, on compliance with Sharia, because we have different schools of jurisprudence, as Dr. Omar and Dr. Ibrahim knows. We have Hanafi, we have Shafi'i, we have Maliki, we have Hanbali, and in each school of jurisprudence, there are differences in relation to arbitration. I'll give you an example. In regarding in financial instruments like ijara and like the lease, which is lease to own arrangements, there are different connotations and different interpretations. Also, the definition of profit and loss, and we can bring other examples, but the first consideration refer to a specific school of jurisprudence rather than to see just Sharia in pure definition. And by doing this, you can, or to find a way to maintain the Islamic finance requirements, which is your good faith and the other party faith, and to be within the global dimensions and to ensure the enforceability, I would suggest two mechanisms. The first one is to refer to specific, as I mentioned now, to refer to specific school of jurisprudence, Islamic jurisprudence. And the other way is to refer to standardized interpretations like the one of Accounting and Auditing Organization for Islamic Financial Institutions, AUFI, and this is well known. This is equal to the IBA in conventional international arbitration. This is equal to Code of Conduct or Code of Ethics under the ICC or OLCIA or SIAC or other international organizations. By narrowing this into such international organization rules, it means you avoid the uncertainty and the ambiguity. That is the first consideration. And a vivid example of that, and I'm quoting this right now from one of the disputes that have come across several years ago. The agreement shall be interpreted in accordance with the Sharia standards issued by AUFI, which, as I mentioned before, has an effect as to the time of contracting. This eliminates ambiguity, uncertainty, and makes your good faith respected, recognized, and without any challenges. The second consideration, when you clarify, when you incorporate Sharia, make sure to distinguish whether this is a governing law or just a framework. Because if it is a governing law and your seat is not recognized Sharia, this means the entire journey will be collapsed. It means you are investing in the hollow. And we have so many cases. I think the time will not permit to mention these cases, but at least we can refer to one of this, like Shamil Bank of Bahrain versus Beximco Pharmaceutical, in which the parts incorporate Sharia, and the English court, not because the English court's against Sharia, it is not, because that is a misconception. The English courts simply clarified that Sharia is not one of the recognized systems, and we cannot. So the exclusive framework governing law will be the English law, as simple as that, which is right from my own perception and from an objective view. So when you do this, you have to make sure that it is just a framework, rather than a governing law. That is also a second consideration. I can see Diane is telling me, Imad, you just have few minutes left, and I will stick with the few minutes left, Diane, don't worry. The third consideration for that one is, I would say, the arbitration clause, crafting, not drafting, the crafting of arbitration clause. And we all know, sometimes you call it midnight clause, or others they call it 8 o'clock morning clause. I would say sometimes 6 o'clock morning clause because of the time zone difference, whatever you name it, whatever you call it. And as my colleagues, they know that because people thinking on the scope of work, delivery, warranty, guarantee, back to back, da 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 da. And when it comes to this, and I still remember one of my professors, he makes a very nice analogy that it is as if you avoid talking about divorce while at the procedures of marriage. So people don't like to talk about divorce. which is the clause of arbitration. That is very important. I think we need another webinar for crafting the clause, but for the time being, make sure how to integrate Islamic principles within this clause, whether it is a standalone clause or multi-tiered clause. That is very important for the crafting. If you allow me to just give you an example how to integrate, and this is also one of the examples that I have come across in my work as a chair in one of the
So, Ahmad, at
arbitrations.
this point,
Please,
so you did ask if I would allow you. And
please.
regrettably, I'm not going to be able to allow you at this time. I will allow you later during the webinar and at a appropriate time that you will know when it comes, because there is something coming at the end of this webinar. You did mention that we needed an hour and a half, and trust me, at the end of this webinar, there will be an announcement made that will allow you to do that. So taking off from there, Ibrahim, let me come to you. And, immediately I'm going to ask you about other forms of dispute resolution other than arbitration. So in what ways can the Islamic principles of conciliation be applied to commercial or investment disputes amongst Muslim entrepreneurs or corporations today? And how can Muslims doing business with non-Muslims balance these alongside contracting in a commercial world, especially taking into consideration that a dispute may arise and parties want to be comfortable with whatever means of dispute resolution, they will be choosing, be they Muslims or non-Muslims. Ibrahim, please attempt to give us a response to this. You're muted, Ibrahim.
Thank you, Diane. The Islamic principles of conciliation, sulh or sulha, can be applied to commercial and investment disputes, whether among Muslim entrepreneurs or in partnerships with non-Muslims. In Islam, the conciliation, also known as sulh or sulha process, emphasizes resolving disputes peacefully, fairly, and efficiently. The Holy Quran further encourages conciliation and honoring agreements, reminding us that disputes are best addressed through dialogue and compromise rather than protracted conflict. In commercial contexts, this principle translates into practices that protect the interests of all parties while maintaining justice and trust. In Islam, conciliation, sulh, emphasizes resolving disputes peacefully, fairly, and efficiently. The Holy Quran encourages conciliation or reconciliation over conflict. In in chapter 49, verse 9, the chapter known as Surah Al-Hujurat, which is chapter 49 in verse 9, Allah Almighty instructs with the following: and if two parties or believers fight, and if two parties of believers fight, make peace between them. Then if they return, make reconciliation between them justly and act equitably. Indeed, Allah loves those who act equitably. So this verse highlights that conciliation is the preferred means of resolving disputes, and that achieving justice through conciliation is both ethically and theologically superior to litigation or adversarial conflict. For Muslim entrepreneurs and corporations, sulha can be applied in several practical ways, such as having pre-dispute agreements and clauses. For example, including a clause or provision in contracts that requires mediation or conciliation before initiating litigation. This ensures that parties commit to resolving differences amicably. Another suggestion is to have transparent negotiation. As another practical way for sulh or conciliation to be applied is to have transparent negotiation, maintaining honesty, clarity, and fairness in business dealings aligns with sulh, conciliation, and often prevents disputes from escalating. Another practical way is to have mutual compromise with justice. So sulh encourages solutions that are equitable, balancing the rights of all parties rather than favoring one side, which is particularly useful in investment or joint ventures where both parties share risks and rewards. Like Dr. Umar mentioned and Dr. Imad have already mentioned, the different types of Islamic contracts and financial instruments that exist that include partnerships. When Muslims conduct business with non-Muslims, these principles can be integrated with conventional commercial law. Arbitration and ADR frameworks are familiar, enforceable, and neutral, yet they can incorporate the ethical spirit of sulh. For instance, parties may agree to mediate disputes guided by fairness, transparency, and mutual respect, ensuring that all parties feel comfortable with the process. Consider a practical example of two partners in a joint venture face a disagreement over revenue distribution. By applying sulh principles, they can negotiate a solution that respects both parties' contributions, avoids litigation, preserves the business relationship, and maintains reputational integrity. The benefits are clear, crystal clear, in fact. Sulh reduces costs, limits delays, and fosters long-term trust, and all essential in today's competitive business and investment environment. It also allows Muslim entrepreneurs to operate ethically while complying with global commercial norms, balancing religious principles with legal enforceability. In conclusion, Sulh provides a flexible, ethical, and effective framework for dispute resolution. By combining Islamic conciliation principles with conventional arbitration and mediation mechanisms, Muslim businesses can resolve conflicts peacefully, fairly, and sustainably, ensuring that justice, trust, and ethical integrity remain at the heart of commerce. That concludes my points. Thank you.
Thank you very much, Ibrahim. It is this time when I will come back to asking Dr. Umar about Islamic financial arbitration, and a question that serves or is some sort of an elephant in the room. When it comes to Islamic financial arbitration, is this exclusively for Muslims, or can non-Muslim parties and arbitrators also engage in this field of practice?
Wow, that's a big one, and it's a crucial point. Like you said, is the elephant in the room, and I don't know if I can really dissect the elephant. As it is, it's too big for me to dissect. Anyways, yeah, I think we should actually put this question up for the participant as well, if possible, to ask whether Islamic finance arbitration is exclusively for Muslims or not. And let's see the feedback while I speak. Okay, great. Now, Islamic finance, of course, is not exclusively, oh, I shouldn't say this. I think we should have you answer the question first. It's not exclusively actually for Muslims. Non-Muslims can actively participate as parties, party representatives, and even arbitrators. The key requirement is this, and listen to this very well, is the expertise in the field of arbitration. And I guess this is part of why CRB Nigeria and the OIC Arbitration Center collaborated to bring you this specialized webinar today. And I'm sure you're going to hear more at the end of today, as Dan mentioned earlier. Now, commercial arbitration generally falls under Islamic commercial law, and there's nothing restricting non-Muslims from engaging in Islamic finance-related business, including dispute resolution. Now, while I'm tempted to go further to review the views of classical Muslim jurists, on the issue, I think Dr. Imad alluded to, different views of schools of thought and Islamic jurisprudence here. I don't want to go into that because we really need time. We need more time to discuss that. Hopefully in our future engagement, we'll be able to do that. Now, what I want to say is I'm conscious of the limited time we have here today, so I will just restrict myself to the more pragmatic view that fits the increasingly globalized world today. Now, the key considerations are not the parties or arbitrators' religious beliefs, but rather the nature of the dispute and the governing law. And I'm sure you've been told a little bit, by Dr. Imad and how you kind of craft the governing law, if I should use that word. Now, Islamic finance contracts are often based on Islamic legal principles, and arbitration is chosen as a dispute resolution mechanism to ensure these principles are applied correctly. Now, if you look at this whole kind of concept, the nature of Islamic law and arbitration itself, the fundamental requirement for an arbitrator is not their religion, but their expertise. In Islamic finance disputes, arbitrators must have a deep understanding of both international commercial arbitration, and in the context of Nigeria, we talk about the domestic arbitration law and the relevant Islamic legal principles. Many arbitration institutions, such as the Asian International Arbitration Center in Malaysia, have specific rules for Islamic finance arbitration that allow for the appointment of arbitrators with the necessary expertise, regardless of their faith. The arbitration rules of my own center, the OIC Arbitration Center, allows parties to resolve their disputes while relying on Islamic legal principles if they have a dispute relating to an Islamic finance contract. So while a non-Muslim may be appointed as an arbitrator in an Islamic finance dispute, the arbitral award from the proceedings must conform with the mandatory Islamic legal principles. This is why it is essential to acquire the requisite knowledge and, of course, the expertise in fundamental principles of Islamic finance contract and arbitration if you intend to specialize in this field. Thank you.
Thank you very much, Dr. Umar. That was straight to the point, really concise. So it is comforting to know that it's not essentially about your faith. It's about your expertise, what you know in these two areas. First being arbitration and the procedural norms of arbitration. And secondly, what you know about the principles of Islamic financing. So it's really a go to school thing, right? Go and get schooled.
Yeah.
On that premise, we will talk about something, and I'm tilting you more in the direction of reality, right? And what the client thinks. So let's talk about public policy. And let me come to you, Dr. Emad. Public policy remains one of the highest barriers to enforcement of Islamic finance awards. Arbitrators in the room know that public policy is one of those, really big elements of enforcement that we all struggle with. At what point is this not going to be expanded beyond the scope that we want it not to be expanded, beyond? But in the light of recent cases, let's talk about the Dana Gas case, for instance, Gas and Bezimco case, right? What practical strategies would you recommend to mitigate enforcement risk in both Islamic and non-Islamic jurisdictions? You're muted, Dr. Ahmad. You're still muted.
I'm sorry. It seems we have, thank you, Diane. It seems we have another big elephant now in the room, which is the public policy. This is a big elephant. And it is the classic term. This is the rolly horse, the public policy. I think in order to, especially with the Islamic finance, if we go to cases, and I think that, thank you for drawing my attention for this case. This is a very interesting case because the parts agreed to apply the Islamic Sharia principles And they selected the seat to be London. London is well known based on Queen Mary surveys from 2006 until the last one in 2025, and based on other surveys, attractive, efficient seat for arbitration. But it is not enough to select an effective and Islamic seat for arbitration. The first advice for my colleagues to select a seat in which Islamic Sharia principles is well known and recognized. For example, Kuala Lumpur, Dubai, Bahrain, and even they can select London or Paris or Hong Kong or Singapore, provided they abide their principles, their Islamic principles with codified rules by international standards. And I'm just building on my friend Dr. Roma regarding the OIC, Organization of Islamic Conference Arbitration Center. There are Islamic, finance disputes between Muslims and non-Muslims. It is not the religion. It is not. It is the agreement on the rules. Once it is having one definition, one interpretation, and that takes us back to the importance of crafting rather drafting. So it is about the seat. For example, if we are going to select a nice piece of real estate, it's always location, location, location. It's also in arbitration. You have to make sure that the seat you select will accommodate your crafting, will accommodate and recognize the way the governing law, the procedural law, the rules and everything. One of the nice example I still remember now, and when I was the chair in one of the arbitration, my colleagues coming from the common law, mine, and I know I studied the common law, civil law, and Sharia law. And the arbitral award is going to be enforced in one of the Middle East countries. And in such country, there is no acceptance for letter of attorney without being attested. It should be an attested power of attorney rather than just a delegation or an authorization letter. And we have this debate, and when we checked with the seat for enforcement, we realized that yes, if we haven't been provided with that attested power of attorney, the arbitral award will have challenges in enforceability. That is the mindset of we have to think about when we craft the arbitration clause, because public policy here, this is the nightmare, this is the big elephant, because if you violate the requirements for the power of attorney, it means you violate the public policy. So that's one important consideration. The other one, we need to think which country is pro-arbitration or friendly arbitration jurisdiction, and which one is not friendly arbitration jurisdiction for Islamic financial disputes. Because, for example, in some countries, the grounds for annulment, the interpretation of public policy is minimum intervention, maximum support, while in other jurisdictions, it is maximum intervention, minimum support. So that's also a part of the crafting we have been talking about. And for public policy, my colleagues might be surprised that it has no standard definition. In some jurisdictions in arbitration, they call it public order. In others, they call it public policy. In third jurisdictions, they call it public morality. So we need to make sure that this jurisdiction in which our contract will be operational and our arbitration clause will be enforced and will be seated, we have to make sure that there is a well-defined an arbitration-friendly jurisdiction, that they have maximum support for Islamic finance disputes rather than less support. That's, I think, the most important. And I will conclude this with the wording, I'm quoting now, with the wording in the English court related to the case that you mentioned, Diane, about Dana Ghaz, that the English courts, the judiciary, concluded that Sharia principles were not a recognized system of national law for the purpose of the Rome Convention. Therefore, they couldn't be applied as a governing law. That is the consideration of public policy and related to the importance of crafting. While in other cases, it has been the Sharia principles applied simply because the parties avoid the public policy and make it an integral part of the rules. And that's why we have to, if I may highlight the importance of that regarding the public policy, I think we need to consider the SCC. The S stands for specify the doctrinal reference. The C, you have to make sure about clarifying the role of Sharia. And the final C is to construct an arbitration clause that is not only recognized but also enforceable. And that is because the entire journey is about enforceability. The entire journey is about getting your right fast, efficient, and effective way. The last point here regarding the Islamic finance and Islamic, Sharia and disputes, recently there are reality versus perception. The perception about Middle East in general and about Gulf states in general that they have some restrictions on public policy. But on the recent 5 to 3 years or 3 to 5 years, there are many developments, considerable developments that we cannot accommodate here. But one of them in the Saudi law now, that is, there is a reform that the necessity or the compulsory of having an arbitrator, sole arbitrator or a chairman with background in Islamic law or Sharia will be deleted because the trend for globalization, to be part of the competitiveness, to do better with your economy. If you want to be global, you have to act global without violating your rules. So that is also something in related to the public policy. And thank you, Diane, for bringing this important point.
Thanks a lot, Dr. Ahmad. So in summary, what we should be looking at is starting from the end and walking back to the beginning. Enforcement. How do I think about getting out an enforceable award? In what jurisdiction am I thinking about enforcing that award? And then I can craft. Dr. Ahmad, this word has come to stay because I see that even in the chat box, everybody is buzzing about crafting an arbitration clause rather than drafting one. And this brings me to you, Dr. Umar. Let's bring it home, right? So with the current Nigerian legal framework governing Islamic finance and arbitration, what are the critical updates on governing law and enforceability of Islamic finance arbitration awards that practitioners should be aware of? I'm asking you this question because of the role you play on the CBN panel of experts team. So this is us stealing, those insights you're giving to the CBN here for free. So Dr. Umar.
Thank you very much, Dan. And it's glad to be back home since you're bringing this whole discussion home. And even though I'm far away, and this is a great question. And for Nigerian lawyers and finance experts who are here with us today, it is important to briefly touch on the Nigerian legal framework governing Islamic finance arbitration. And as Diane mentioned, I'll give some insider information, based on the council at the CBN that regulates Islamic finance in the country. Now, for non-Nigerians who are also with us today, the legal framework in Nigeria is not so different from what is obtainable in most other jurisdictions. Just as Dr. Imad mentioned, the Saudi law for arbitration basically substantially complies with the ancestral model law. And it's also important to note that the Nigerian's Arbitration and Mediation Act 2023 reflects a significant alignment with international best practices, as it is modeled on the ancestral model law on international commercial arbitration of 1985, as amended in 2006. Now, the Arbitration and Mediation Act 2023 of Nigeria has relevant provisions that may guide parties to an Islamic finance contract in choosing the applicable governing law. Let me break it down for you, and I think this is really important. Listen to this. The governing law for the contract is expected to be Islamic law when you're talking about Islamic finance contract. So the applicable substantive law or lex causae in Islamic finance contract must be Islamic law. I'm sure the next question on your minds will be, what is Islamic law and which Islamic law? And I think Dr. Imad actually, was talking about different schools of thought, the need to kind of specify to say, okay, we are referring to the AOFI standards. It has to be something codified, something people can relate to, rather than relying on expert witnesses, which will just come. Sometimes in proceedings we see they contradict each other. Sometimes you have to kind of bring them together, hotbed, try to kind of get them to agree on some principles. So uh, clarity is important because when we say Islamic law, which Islamic law? So clarity is important when drafting Islamic finance contracts. In the context of the Nigerian legal framework, one thing we have repeatedly, when I say we, I say the council, which is the Financial Regulation Advisory Council of Experts, which is the highest body at the Central Bank of Nigeria regulating Islamic finance industry. One thing we have really actually emphasized on, and before I even say that, as I speak, the council is currently in a meeting, and I had to step out of that meeting to join you at this webinar. Today is the third day of the meeting. So just to tell you the kind of the volume of work the council has to do, reviewing contracts, a lot from different banks. Now, when the council reviews legal documentation sent to it from different Islamic banks in Nigeria, it emphasizes clarity, certainty, and predictability when it comes to the governing law clause for obvious reasons. Now, for the core Islamic finance documents involving Sharia contracts, the Council has adopted a policy that allows parties to clearly state what they mean by Islamic law. Permit me to read a sample clause which emphasizes the nature of Islamic law. Normally, when we have all sorts of clauses, we always try to amend it in this way. We say, quote, this agreement shall be governed by and construed in accordance with Islamic commercial jurisprudence, as interpreted by the Financial Regulation Advisory Council of Experts and the laws of the Federal Republic of Nigeria. So from the court, it is clear that we are referring to Islamic law as Islamic commercial jurisprudence interpreted or as interpreted by the Council of the CBN, because statutorily, that's the highest body that has the powers to interpret it. And the decisions of this council are available. I think, a compendium was published a few years ago and it's available online. We are also planning to publish the next compendium so that people can easily refer to this. And for instance, I'll say this, Section 15, Sub 1 of the Arbitration and Mediation Act 2023 of Nigeria provides that the arbitral tribunal shall decide the disputes in accordance with the rules of law that is chosen by the parties as applicable to the substance of the disputes. This is where the lex causae is important, which I'm emphasizing on. So parties can clearly stipulate Islamic law as the applicable law. But again, clarity is key, just as I've explained earlier. Now, the next thing I should explain is the mandatory law of the seat of arbitration. Since we are discussing Islamic finance arbitration as domestic arbitration in Nigeria, so the lex arbitri, of course, will be the laws of the Federal Republic of Nigeria. Now, finally, the procedural rules to be used in arbitral proceedings should, as much as practicable, avoid any process or procedure that violates core Islamic legal principles. Now, Section 15, Sub 5, again, of the Nigerian Arbitration and Mediation Act 2023 expressly states that in all cases, the arbitral tribunal shall, and I repeat with emphasis here now, shall decide in accordance with the terms of the contract. Therefore, parties in Islamic finance contract should ensure the terms and conditions of the contract are in line with Islamic principles. Thank you.
That was extremely insightful, Dr. Umar, so that, we can give, I see a lot of questions, so we can give time for these questions to be answered. I did mention that this area is a very novel area of, not only commercial practice, but dispute resolution, arbitration as well. I'll quickly ask Ibrahim, there is often a perception about arbitration awards, especially those based on Sharia principles, like we're discussing now, that these are difficult to enforce in non-Islamic jurisdictions. In reality, and based on your experience with uh, the center that you're affiliated with in Canada, how do enforcement mechanisms under laws such as the New York Convention? Dr. Emad, I told you that we will deal with New York Convention at some time. There's no running away from it when we're talking about enforcement. And domestic arbitration acts address these concerns. And what practical steps can parties take to bridge the gap between perception and reality? Ibrahim, please.
Thank you, Dan. Let me just address a common perception that arbitration awards based on Sharia principles are difficult to enforce in non-Islamic jurisdictions, such as Canada. While this concern is understandable, in reality, enforcement mechanisms under international and domestic arbitration law largely address these issues. Let's first consider the New York Convention of 1958, ratified by Canada. This treaty ensures that arbitration awards from one contracting state are recognized and enforceable in another, provided the award meets formal requirements. Importantly, the convention does not discriminate based on the substantive law used in the arbitration, whether the award is based on Sharia principles or common law. As long as the arbitration process is valid, the award can be enforced. Similarly, Canada's domestic arbitration laws under provincial arbitration acts such as the Ontario Arbitration Act recognize and enforce foreign and domestic awards, including those based on religious or non-Canadian law, so long as they meet procedural fairness standards and do not violate public policy. To illustrate this in practice, I recently conducted an international arbitration between two Muslim entrepreneurs, one from the US and one from Canada, regarding a contract dispute. Both parties specifically selected me as the arbitrator because they wanted an Islamic arbitrator who could apply Sharia principles, while also adhering to international arbitration rules under under the New York Convention and the relevant domestic or international arbitration act and domestic arbitration acts, through a process that was fully compliant with procedural fairness, transparent, and well documented. I was able to issue an award based on Islamic contractual principles that was also consistent with international arbitration standards. Later, the award was successfully enforced across jurisdictions, demonstrating that Sharia-based awards can be recognized and executed in non-Islamic legal systems, provided that they comply with procedural safeguards. From this experience, several practical steps can help bridge perception and reality, such as number one, how clearly drafting arbitration agreements and by specifying the seat of arbitration, governing law, and the application of Sharia principles if agreed upon. Also, if we ensure by ensuring that procedural fairness exists and takes place by selecting competent, neutral arbitrators, giving parties full participation and documenting the process transparently. Number three, by integrating enforceable frameworks, confirming that awards are enforceable under the New York Convention and domestic arbitration laws. And number four, by educating stakeholders, by explaining that Sharia-based awards are enforceable like any other arbitral award, reassures parties and courts alike. The reality is that enforcement of Sharia-based awards in Canada or other non-Islamic jurisdictions is not inherently more difficult than awards based on commercial or civil law. With careful planning, transparent procedures, and adherence to recognized arbitration standards, parties can rely on arbitration as a trusted, effective, and enforceable method of dispute resolution, regardless of the substantive law applied. In conclusion, my own experience demonstrates that international Islamic arbitration, when conducted properly under the New York Convention and domestic arbitration statutes, is not only feasible but also enforceable. Concerns about enforcement are often rooted in perception rather than reality. And with proper safeguards, Sharia-based arbitration can provide fair, ethical, and legally recognized solutions for cross-border commercial disputes. That's my contribution. Thank you.
Thank you very much, Ibrahim. And at this point, it will be manifestly unfair of us not to take questions and try to, provide some answers to the number of questions I have seen thrown at, the panelists. And I will begin with a question that is from my senior, Leonard Silk Funke Adekoya. I'm not going to tell you how she's my senior, but I shall be partial in this regard and begin with her question. And what she has asked is, fairness is a concept that different people interpret differently. If the arbitrator's interpretation is different from that of either of both parties, has he or she, being the arbitrator now, not substituted their contract terms for what the parties agree on? And I will ask you, Dr. Umar, to please, provide an answer to the Leonard Silk in 1 minute.
Sorry, can you repeat that quickly? Sorry.
What she has said is fairness is a concept that different people interpret differently. If the arbitrator's interpretation of fairness is different from that of either or both parties, has the arbitrator not substituted their contractual terms for what the parties agreed on for his own interpretation or her own interpretation?
Yeah, that's an excellent question. And first thing I'll say is this: the lex causa actually will have to trump every other thing. And if Islamic law actually is the governing law of the contract itself, the principles of fairness based on Islamic law will be applied. So the arbitrators do not have any inherent powers to actually use their own interpretation of fairness. So they have to base it on what is fair in Islamic law. And there are a lot of rules regarding this. There are principles regarding fairness. Time will not permit us to kind of look into all this today. But the standard to be used is an objective standard, which is based on Islamic perspective of fairness and not those of the tribunal members. Thank you.
Thank you very much, Dr. Umar. I do believe that this allays the anxieties of the Leonard Silk. Dr. Emad, there's a question that is directed at you, and it reads, what happens where the parties are multinational with different jurisdictions in terms of the schools of thought? How can the crafting be done to satisfy all of the parties?
This is also a very interesting question. Shall I have 1 more minute or 2 or 3 minutes? How many minutes?
For the sake of fairness, Dr. Emad, 1 minute.
Thank you. That's yes, equal opportunity. Okay, it's a really very interesting question, but the answer is straightforward. It is about the rules that you craft in the arbitration clause, meaning whether this jurisdiction is party to New York Convention. It is almost 172 countries now, or in this country, the jurisdiction is party. For example, in the Middle East, still Libya is not a member in the New York Convention. Yemen is not a member in the New York Convention. So this means that in terms of jurisdiction, we have to make sure that this is an enforceable and in a pro-arbitration jurisdiction. That's one. 2, standards. I still remember 25 years ago now, when we were in Queen Mary for my first LLM, we remember that what shall we do? We read the rules, and then we read the rules, and then what shall we do? We read the rules. So we have to make sure to refer to the standards rules like this OFI and the Islamic advisory boards and others, and to read every single word. Thirdly, if multi-organizations are working, and instead of visualizing the operation of the contract, just anticipating that tomorrow morning the dispute will arise. What shall we do? What will be operated in terms of seating, enforceability, predictability, and lastly, we can look into the statistics, the rate of enforcement in the jurisdictions, how long it takes for the enforceability, and to what extent the judiciary do have understanding of the Islamic finance disputes. This is in brief what multi-organizations can do in order to go for a safe passage in within the 3 minutes you will give it to me.
Thank you, Dr. Ahmad. Dr. Ibrahim, there's a question on handling risk management, and this is one from Olaitan Komolafe. And Olaitan wants to know, how does Islamic finance handle risk management?
I think I would like to maybe ask Dr. Omar, pass that on to Dr. Omar,
Yeah, thank
given
you.
the expertise.
Thank you, Dr. Ibrahim. For the question on risk management, I think this is a subject we teach for a whole semester, and I'm expected to answer it within a minute. Risk management, it's actually embedded in Islamic finance. You know, when you say every transaction has to be tied to a real asset, that's the first point. That tells you that every transaction has to be tied to a main transaction, a real economic activity. That tells you you're already managing a risk. So you don't just have bubbles in the sky where people just kind of lend money without any real transaction. So that's one. The second point is ownership actually goes with the risk itself. So if you own an asset, you actually it goes with the risk. So there's that risk sharing kind of concept in Islamic finance, and it's embedded in Islamic legal principles. So there are a lot of tools that are being used globally now, you know, for risk sharing or risk management in Islamic finance at a very sophisticated level. Even the sukuk you see, the federal government sukuk in Nigeria you see, in the structuring, there are risk kind of management tools that have been built into the structuring because we approve, you know, that sukuk at the council level at the CBN. So I know the whole structuring. So there are a lot of risk mitigants that have been embedded in it. So risk management, it's actually recognized even in the Quran itself. There are verses that relates to it. And when you go to the prophetic precedents, which we call the Sunnah or Hadith, you also have principles that relate to risk management. So that's why in the modern Islamic finance industry, these have been structured into tools. And the first one we always say is profit. Actually, if you are entitled to profit, then you must be also be ready to bear the risk involved in the transaction. There is a legal maxim on that in Islamic finance where the risk actually goes with the profit. Every transaction is risky. So if you have to kind of make profit from a business venture, you've got to be ready to also assume the risk involved. Thank you.
Very many thanks, Dr. Umar. There's a question here, and I see we've got just 3 minutes. So I will ask that you restrict your response to 1 minute. This is me wielding that moderator, the authority of the moderator. Now, what are the enforcement procedures for arbitration awards of this nature where it involves multiple organizations in different countries with different laws? Dr. Ahmad, 1 minute, please.
Yes. For the enforceability, it should be arranged in advance in crafting the clause. But with the multiple organizations, there is either bilateral treaties for the enforcement, like Riyadh Convention, or it could be an international treaty like New York Convention. So that is and the procedure for that is straightforward in all these jurisdictions because the 16 provisions of New York Convention, it hasn't been changed even by letter by all the signed countries since 1958. So the most important is just to ensure that the lawyers in charge of enforcement is fully aware of the foreign arbitral awards enforcement procedures and also to look into the rate of the local courts in this context. Thank you.
Thank you. So at this point, I'm feeling very happy with myself that I was able to rein in the doctor and the fellow and the professorial candidates to just 1 minute. The very last question is from Professor Nelson Ojukwu Ogba. And what he wants to know is, what should be the implication of the element of fraud in a sukuk agreement? Should the contract be remediable or would morality influence the continuity of such a contract? Anyone can have a go at this, please.
Here, or I hope I have 3 minutes, but I think Mr. Ibrahim will have to take this. I think he'll start, and we'll.
Yes, so I would like to hear from Dr. Omar, especially given the fact that, he probably deals with a lot of these agreements and working with the financial institution. I would love to just quickly see what his experience has been.
Okay, thank you very much. Yeah, when it comes to Sukuk and elements of fraud, and I think we're not going to treat it differently from the English common law. And I have to say that, advisory really, is not going to be treated differently. It's the same. The principles remain the same. Fraud remains a fraud. So if you have a fraud in a Sukuk transaction, then you have to find a way to remedy it, or it can actually void a contract ultimately. I don't want to go into the issues of the PI and ID case, involving Nigeria, basically, but when we talk about Sukuk, the principles remain the same. And this actually also tells us the interaction between the Islamic legal principles and positive law in Nigeria, as it were. Now, when you have these two interacting, as much as possible, the principles of English law will apply to many things within the contract itself. So when we even talk about Sukuk, and I'm actually saying this based on the structuring of even the FGN Sukuk, most of the principles of contract, and when I say principles of contract here, I mean the English common law based principles are also applicable. And I always tell people, like I mentioned to an audience in Malaysia last week, at an Islamic arbitration conference, there's no much difference between English common law contract and the Islamic law contract, basically. There are only very few differences. And there's even an article I would recommend to all of you to read, written by John Makdisi. It's the Islamic origins of English common law. There are a lot of similarities. So when it comes to fraud, fraud is treated as fraud. So the contract actually is voidable. And if something serious, of course, you can void the contract and at that point. But again, we always say the devil is in the details. It's when we have an actual case, I'm the head of an international arbitration center. It's when we have a case that will actually apply the principles to it. So whatever I've said now, do not use that against me when I sit as an arbitrator in future. Thank you.
Thank you very much, Dr. Umar. So what he's done is just, provide us with a disclaimer so that you don't hold his words against him. I must thank everyone for joining, especially our panelists. But I did mention that there will be an announcement at the end of this webinar. Regrettably, we've come to the time when we cannot take any more questions. And so we will turn it over to the chairperson of the Chartered Institute of Arbitrators, Nigeria branch, Mrs. Shola Adegbomire, to address us and then provide that announcement for us. Mrs. Adegbomire, please.
Thank you very much. Thank you very much. Well, before you finish, there was something Dr. Ahmad said he was going to tell everybody what SCC stands for.
He told them.
And I think he forgot, and people want to know.
He said it.
And I want to know as well.
No, he said
it's
it.
also in the chat box. Okay. It's in the chat box. People are asking. Okay, maybe we missed it because I see some other people asking. Okay, thank you very, very much. Thank you very much. I can't thank the three of you enough. I can't thank Diane enough. This has been a really wonderful webinar. And, I'm sure the panelists are also looking into the chat boxes and you're seeing the comments from the people talking about. Some say this is their best webinar so far out of the 4 we've had, but this has been very interesting for everybody. There are lots of Muslims and lots of non-Muslims, and I think everybody has found this very interesting. I'm so happy we even have a professor, and even the professor had, something to ask. So it just tells us how engaging this has been. We have SANs, our senior Mrs. Funke Adekoya, even she had questions to ask. I mean, this has been very, very engaging, and I think we're going to have a lot of interest in Islamic arbitration. I want to say how this panel, this webinar came up. About 10 years ago, the Muslim Lawyers Association wrote to London, the Chartered Institute of Arbitrators, seeking Islamic arbitration training. London wrote to us asking if we can provide it. Unfortunately, we couldn't because we didn't have the resources. Then, fast forward to earlier on this year, when I met a gentleman called Dr. Imad, who is also on this panel. And I found out that he was into Islamic arbitration. So I said, please, there's something my people have wanted for more than 10 years, Islamic arbitration training. Can you do? Oh, he said, I know the person. I will tell you the person to go to, Dr. Umar Hussein. And coincidentally, he's a Nigerian. He heads the OIC Islamic Arbitration Center. But Dr. Imad is a very busy man. So between him telling me and him sending me the information took another long time. And, he is very busy, traveling all over the world, doing this same thing. Finally, he links me up with Dr. Umar, and there has been no stopping us. Since then, this is just the lowest hanging fruit in all the things we're planning to do. Apart from this, we want to have the full Islamic arbitration masterclass, which is going to include Islamic financing, Islamic contract documentation, without having a good understanding of those two. That training will come towards the end of this year or early next year. We'll be having the training. We're going to advertise. We have all your emails of those who have registered, and we will send you information about the training. It's going to be a proper full course. We'll send you information. The CIM and the OIC Arbitration Center are also entering into an MOU to work together. And I mean, that is just another big thing. And everybody will know when that is concluded. Friends, a standalone conference in Nigeria, other West African countries, they are all interested, invited. I know that there are people from all over the world. I wish we had said, if you are from outside Nigeria, please indicate on the chat box, and you can still. I've seen Pakistan, I've seen some other countries where people are attending from today. You will also know about the course, and that's the course, the conference. They're all big things. We're also having something. I know that there are a lot of young lawyers and about Islamic arbitration, because it's one area, I call it a hidden area of arbitration that people don't know about. And there's so much happening in that area. Yes, please, there's a poll going on, a follow-up webinar after this one. If you're in Lagos and you have advertisement, sukuk, something about sukuk, now I understand very well why that is. It's probably that the financing for that place was from a sukuk bond, when today that there is so much happening. I can see people cross-border and sukuk disputes. People want to know about everything. So definitely we will still have another Islamic arbitration and finance seminar. I hope that when we have that one, that and they have been able to present it in a way that we all understand it. It's so simple. It's not as complicated as many of us thought it would be. I mean, we've been 1.5 hours and we still have 800 and something people on 84. 884 here, and not to talk of the number of those who are on YouTube because they couldn't get in here. By the time this webinar was opening, at 11:30, we already had about 150 people. And it's not just that we have a crowd, no, we have people who are engaging. Everybody has engaged with the webinar. So that really makes me very happy. As the whole, let me call it projects, the projects of the CIAB and the OIC Arbitration Center, as the project develops, we're going to get everybody involved. We're going to have something with the business community, with the lawyers, with students, and then leading up to the conference and the course, the full course itself. So thank you very much, Dr. Imad, for introducing me to Dr. Omar. Thank you, Dr. Omar, for bringing Dr. Hussein. And thank you, Dr. Imad, for all the work we have done together in the last few months. Somebody asked a question that, is it a coincidence that they are all Husseins? And that maybe that is why they've done such a great job. I thought that was very interesting. Once again, I don't want to talk. The talking has already been done. Please, there's another poll going on. Please fill the poll. But once again, I just want to say, and Diane, it wasn't a mistake bringing you on as the moderator. It was not at all. Thank you so much, Diane. You've done a great job. You've been able to control the time and elicit as much as we need to know within the short time. Like Dr. Omar said, one of the questions somebody asked was something that is a whole course for one semester, and he had to answer the question in 1 minute. So thank you to Dr. Agbelusi, who is behind the scenes along with the whole secretariat. Thank you to the OIC Arbitration Center, because this webinar is being run by the Chartered Institute of Arbitrators and the OIC Arbitration Center. We're running this together. The OIC decided we won't run a seminar this month. We will run this with you. So thank you very much to the OIC Arbitration Center. Yasmin, I'm sure you're somewhere. Our own Dr. Agbelusi, to everybody, I say thank you very much. Have a wonderful weekend. And next month, our seminar, our webinar for next month is on OHADA. OHADA is the arbitration for the other West African French-speaking countries. There's a lot of work going on in that area that we do not know about. And yet Nigeria is bordered on all sides by French-speaking countries, Republic of Benin, Niger, up in the north, is also French-speaking countries all around us. And so we need to know what is happening in that area. So next month, we will be having our webinar on OHADA, getting to know our neighbors and getting to know what we can do with our neighbors. So the flyers for that one will be going out shortly so that people can start registering. Thank you very much, and have a good weekend, and God bless you all. Thank you.
Thank you so much, Mrs. Adegbomire, chairperson of the Chartered Institute of Arbitrators, Nigeria branch. And at this point, all that is left of me is to thank you, our participants. Without you, there would be no webinar. Thank you for listening. Thank you for participating. And the enthusiasm shown is priceless. And finally, to the Trioka of the Husseins, thank you so much for bringing your wealth of experience, sharing with us without any form of, holding back. Dr. Emad, we cannot thank you enough. At every point we call on you and you answer us. Dr. Umar is our own, so he cannot discard us. When we call on him, he has to respond. Ibrahim, thank you so much. It's really early in Ontario and you made out the time. Thank you. So finally, we see that the poll has gone out. I think this is the second time, but it appeared that from the first poll, the popularity and the preference was to have a follow-on webinar on cross-border sukuk disputes. This time around, we're seeing arbitrability of Sharia questions. So it would appear that maybe there should be two webinars rather than one. But the decision will be taken, and we will ensure that there is another webinar and then the training. So at this point, we will allow our Muslim brethren to have the rest of their day. It is Friday and it is time for Juma prayers. At least in Nigeria, it is. So have a nice weekend and thank you for joining us.